Good morning, Vice Chair Salahi. We are ready to begin.
All right, thank you. Good morning. Welcome to the July 11th, 2025 regular meeting of the San Francisco Ethics Commission. Today's meeting is live cablecast on SF.gov TV and live streamed online at sfgovtv.org/ethicslive. For public comment, members of the public may attend in person or may participate by phone or on the WebEx platform as explained in our agenda document. Mr. Clerk, can you please explain how remote comment will be handled?
Certainly. Public comment will be available on each item on this agenda. Each member of the public will be allowed 3 minutes to speak. For those attending in person, opportunities to speak during the public comment period will be made available here in room 400, City Hall. For those attending remotely, the public comment period can also be provided via phone call by calling 1-415-655-0001, access code 2664-408-5447, followed by the pound sign, and then pound again to join as an attendee. When your item of interest comes up, please press *3 to raise your hand to be added to the public comment line. Public comment is also available via the WebEx client application. Use the WebEx link on the agenda to connect and press the Raise Hand button to be added to the public comment line. For detailed instructions about how to interact with the telephone system or WebEx client, please refer to the public comment section of the agenda document for this meeting. Public comment may be submitted in writing and will be shared with the Commission after this meeting has concluded and will be included as part of the official meeting file. Written comments should be sent to ethics.commission@sfgov.org. Members of the public who attend Commission meetings, including remote attendance, are expected to behave responsibly and respectfully. During the public comment, please address your comments to the Commission as a whole and not to an individual member. People who engage in name-calling, shouting, interruptions, foul language, or other distracting behavior may be excluded from participation.
Thank you, Mr. Clerk. I now call the meeting to order. Mr. Clerk, will you please call the roll under item 1?
Certainly. Vice Chair Salahi?
Aye.
Commissioner Francois?
Aye.
Commissioner Ye?
Aye.
Chair, with 3 commissioners present, you have a quorum.
Thank you. With that, I call agenda item number 2, general public comment. Is there anyone in the room who'd like to offer public comment? Seeing nobody, is anybody in the online queue?
Looks like we have 6 callers in the queue.
All right. Please proceed.
Oh, excuse me, no callers in the queue.
Oh, okay. All right. Seeing as there are no further members of the public who wish to speak, general public comment under item 2 is now closed. I now call the consent calendar. Colleagues, as noted on the agenda, there will be no separate discussions on a consent calendar item unless a request is made by a commission member or a member of the public in attendance, in which event the matter shall be removed from the consent calendar and considered as a separate item. If any commissioner asks to discuss an item, that item will be taken up following action on the consent calendar items on the regular calendar for discussion and action. And I intend to pull the only item on the consent calendar, the executive director's report, primarily because I wanted to have an update during the meeting about the budget process and how it impacts the commission's work.
Great, thank you, Acting Chair Salahi. Yeah, as I mentioned in the report, the budget process is largely concluded at this point. It is still technically going through its final votes at the Board of Supervisors and will still go to the mayor. But at this time, we essentially know what the budget will be, and it's a very positive update compared to the updates that I've been giving you over the last several months. In particular, we were able to get funding restored for all 3 of the filled positions that in previous iterations of the budget had been identified for elimination. We feel pretty good about that because obviously these are incredibly important positions. These are our colleagues. Additionally, citywide, only about half of the filled positions that were targeted for elimination were reversed. So that's about a 50% success rate. Citywide, we had a 100% success rate. We got all of our filled positions restored. So it was a lot of very long, nights and lots of work. I want to recognize Zach D'Amico for all the work that he did. Stephen Massey was a huge part of this as well, and Manny Mandapot as well was supporting us. So I'd be glad to answer any questions you have, but that's the headline. There's lots of other smaller line items within the budget, but this is the one that we will feel in the most direct way.
Thank you. Do any of my colleagues have any questions or comments? No. Thank you, and congratulations. I know you and your colleagues were working very hard, engaging with other city officials to make sure that we could protect the commission's mandate.
Yeah, and thank you for your support. This is a process we all went through together, and it's great to have commissioners that are engaged in this process, and we can find alignment and handle this together.
Thank you. I don't think we need to take action on the executive director's report, but do we need to take public comment one more time? Okay. I invite any members of the public who are in person and wish to provide public comment on the item we just discussed to please step forward. Seeing no one, Mr. Clerk, is there anybody in the queue?
We have no callers in the queue.
Okay. Thank you. Public comment on that item is now closed. I don't know if I need to make a motion to adopt the consent calendar if we remove the only item. No? Okay. All right. Okay. So I now call agenda item 4. This is the show cause hearing in the matter of Matthew Latoki v. San Francisco Police Department. This item is being called in connection with a May 2nd, 2025 referral of the matter by the Sunshine Ordinance Task Force to the Ethics Commission for enforcement proceedings under Section 67.35, subparagraph D of the Administrative Code for failure of the San Francisco Police Department to comply with an order of determination. At our regular meeting on June 13th, 2025, the Commission held a hearing on this matter. Petitioner Mr. Matthew Latoki was present at that meeting, as was Lieutenant Jonathan Ozel, who appeared on behalf of Respondent SFPD. Lieutenant Ozel was named in the referral along with SFPD Chief William Scott. There was no representative of the Sunshine Ordinance Task Force in attendance at the hearing, and Enforcement Director Matthews provided a brief presentation. So I have a little bit more in the preface, if that's okay. Yeah. As part of that hearing, Petitioner Mr. Latoki provided his presentation of the case, and Lieutenant Ozel provided a presentation of the case on behalf of SFPD. Following those presentations, the commissioners were provided an opportunity to ask questions of each party, and we also received public comment on that agenda item. A motion was then made and adopted unanimously by the Commission to table the matter until this meeting on July 11th, and the matter is now before us again to conclude our deliberations. Before we do so, I want to confirm that Commissioner Ye, who was absent from our June meeting, has reviewed the video from that hearing and the evidence and is prepared to participate in deliberations.
Yes, I reviewed or listened to audio of the entire hearing and reviewed the materials.
Thank you. Next, I would like to ascertain whether the parties are present. Mr. Latoki, I don't think I see him here. Is anyone here on his behalf? Nope. Okay. Is there any representative from the police department here?
Yes, Sergeant Walter Ware, W-A-R-E, on behalf of the SFPD.
Okay. And I apologize, I couldn't hear you well. Could you please repeat your name?
Sergeant Walter Ware, that's W-A-R-E.
Thank you.
Thank you.
And although the Sunshine Ordinance Task Force is not a party to this matter, the enforcement regulations allow it to send a representative to present comments or arguments in favor of the referral. Is there a representative present?
Yes, Dean Schmidt on behalf of the task force.
Thank you, Mr. Schmidt. Before we resume deliberations, I would like to remind my colleagues of the recommendation from the Enforcement Division. Ms. Matthews, would you prefer to present that yourself, or? Okay. Okay. As explained by Ms. Matthews previously and in the updated submission, the enforcement staff's position is that the regulations do not provide for monetary penalties or other remedies upon a finding of a non-willful violation. and for that reason, the staff recommends that the commission take no action on this matter. We'll now resume our deliberations. Do any of my colleagues wish to speak on the matter or take a motion before we call public comment? No. Okay. Before we call public comment, I thought it might be helpful to share some of my personal views about where we are here. It has been pretty confusing and difficult to parse through the different provisions of the Charter, the Sunshine Ordinance, and the enforcement regulations, and the relevant provisions of the Administrative Code. But as it stands at the moment, my general understanding is that the Sunshine Ordinance Task Force has the ability to handle disputes about whether or not a record is required to be disclosed by a city agency under the Sunshine Ordinance and Public Records Act. And if it concludes that disclosure is required, it may issue an order to a city official to comply and disclose those records within 5 days. Now, Section 67.21, subparagraph E, provides that if the custodian refuses or fails to comply with any such order within 5 days, the Sunshine Task Force shall notify the district attorney or the attorney general, who may take whatever measures she or he deems necessary to ensure compliance with the provisions of the ordinance. At the same time, nothing states that those authorities have the exclusive enforcement prerogative under that section of the Administrative Code. And Section 67.21F provides that the administrative remedy provided under this article shall in no way limit the availability of other administrative remedies provided to any person with respect to any officer or employee of any agency, executive office, department, or board. Now we get to the other provisions related to the Sunshine Ordinance Task Force. 67.35D provides that any person may institute proceedings for enforcement and penalties under this Act in any court of competent jurisdiction or before the Ethics Commission if enforcement action is not taken by a city or state official 40 days after a complaint is filed. I understand that the prevailing view of that subparagraph is it should be read in conjunction with Section 67.34 and 67.36, which provide that the willful failure of any elected official, department head, or other managerial city employee to discharge any duties imposed by the Sunshine Ordinance shall be deemed official misconduct. I'm cutting out some of the middle of that one. So there is no dispute that the Ethics Commission has authority to adjudicate allegations of willful misconduct or violations of duties imposed by the Sunshine Ordinance. It's unclear the extent to which any authority exists over non-willful violations to hear disputes and make findings, but there's not explicit authority to actually issue penalties for non-willful violations. Do I have any reactions from the city attorney to that so far? That sounds right. Okay, thank you. Okay, so revisiting what was presented in the referral and my understanding of the last hearing, there are two ways to look at the dispute here. One is calling upon the Ethics Commission to decide whether or not, in fact, the records in question fall within the scope of the Sunshine Ordinance or any of the exemptions thereto. That's one where my view is we are not in a position to do that. We haven't received briefing on the exemptions or heard arguments on those particular issues. And it seems like that's an area that's more properly within the Sunshine Task Force jurisdiction. And to the extent there's some reasoned disagreement of law between the petitioner and the department on that, they can resolve that through a superior court process. But there's a second question that we flagged last time, which is, regardless of the underlying merits of whether records must be disclosed in the first instance, did the police chief in particular do anything wrong by ignoring the order from the Sunshine Task Force to disclose those records? And so that's the one that I think we probably can focus on, although, and this I'd like to hear from Mr. Schmidt about, the referral from the Sunshine Task Force was expressly not for an alleged willful violation of the Sunshine Ordinance. So if that's the case, that might streamline if you can confirm that. I understand that there was a motion to refer it under that title was rejected.
Thank you. Yes, Commissioner. And I'd like to start with an apology. I was attempting to appear remotely at the last hearing, and unfortunately, I had a new laptop and I had a sound problem. I'm still not quite sure what happened, but I needed to view the hearing through closed captioning, and I was not able to speak, and I'm sorry I wasn't available at that time. However, I don't have lengthy comments to make, and I can probably give you what I would have at that time. We did not make a finding at the task force. I'm a member of the task force. There's 11 members of the task force. I'm the one attorney, and in fact, my seat is a designated attorney seat. I'm appointed by the Society of Professional Journalists. And the task force has asked me to appear here in both this matter and then line 6. The Lataki matter, we did find a violation. We did not, I'm pretty sure we did not have any kind of a vote as to whether we thought there was willfulness. It was not, we certainly did not have a majority vote on willfulness. I do not believe that most of the members had the view that there was willfulness here. However, we also do not believe that forecloses the possibility that the Ethics Commission might think differently. And so it's our belief that Mr. Lataki could bring this matter to you under the ordinance and ask for a willfulness finding. We do very rarely actually forward our cases under 67.34 to the Ethics Commission. I believe that in the last, say, year and a half, of the probably about 100 cases that we resolve in a year, in the last year and a half, we've sent 2 over, and those have been 2 fairly extreme cases where we thought, yes, there is willfulness here, and we'd like the Ethics Commission to look at that. In the first matter, we thought there was willfulness on behalf of the police commissioner in a matter where it took years of haggling with the police department to go through many different excuses on whether a member of the press could get access to files that were 50 years old. Somebody who was investigating something called the Zodiac Killer. The final excuse we got from the police department for not producing anything from that file was that they still had an ongoing investigation. We thought that that did not seem even close to credible. The other matter that we've referred is also against someone who's now an ex-official of the city, the mayor, the former mayor. And it involves her use of her own phone and her texting habits, and we found that she basically refused to produce any kind of texts, even on official business. And we thought that merited a look by the Ethics Commission. I do not know the status before your commission of that second matter. We did get a denial from the commission, although, as we've seen on other occasions, and in that case, we basically got a one-sentence denial saying we see no evidence, and so we do not know really how that went through the process, and we're not quite sure how much that was actually considered by the commissioners themselves. So we believe that Mr. Lataki asked for 6734 remedy, and as a commissioner has stated, there does not seem to be a question as to whether this commission can look at willful violation claims. However, it is our view that any aspect of the ordinance that refers to the Ethics Commission should be something that is available to a member of the public, a member of the press, who has a sunshine issue. The task force, we agree that we're the primary people on the areas of jurisdiction that we're talking about, which is public records, public meetings, the Sunshine Ordinance, the Brown Act, the CPRA. However, I would say that the ordinance as written, yes, it is a little bit hard to go through and figure out what it's supposed to mean. I would agree with that. But we get what we get, and so the task force would like to work with the Ethics Commission to have a way where we don't send you things that we think you would be duplicating our effort on, but we also see in the ordinance that we enforce that there are things that we need to send to you, and that would be possibly under 67.30 of the ordinance, and that's one of the bases whereby we believe that we're bound to send certain cases not only specifically to the Ethics Commission, but to an agency within the city to also look at what we found. And so when we send that over, we are basically acting in accordance with 6730. You may note that we really do not send many cases over under that provision. Usually it's when a petitioner makes a specific request. It's also our position that 6735D, as opposed to 6735A, does not simply condition 6734. We believe 6735, even though it's not written in the most clear way, gives an avenue whereby members of the public or members of the press can bring something to the Ethics Commission. And it seems to us that somehow the drafters in that provision were sort of giving alternative remedies, alternative avenues. And so we think that there is jurisdiction here, and I know this is in disagreement with what some of the recommendations we've seen are, but we do think that there could be, there should be jurisdiction because of the specific mentioning of the Ethics Commission and of sending certain cases out that we're bound to do to consider non-willful violations, whether it's looking at the merits of the violation or possibly, and this one's a little less clear to me, whether someone should get an order from us and then ask you to order that our order be complied with if you don't have any further remedies. I don't see that that's really something that we should put anyone through the effort on. So we believe that our orders stand on their own. I don't have a desire to get a duplicate order from the Ethics Commission on something, but we also don't have all the possible remedies that this commission can impose. Our remedies are very limited. The scope of our budget, the scope of what we actually look at, it's very different from the Ethics Commission. So that, I think, is a prolonged response to your request about was Lataki a 6734 or not.
Thank you.
Thank
I
you.
have a follow-up question. I don't know if my colleagues have any as well. But you mentioned not wanting to relitigate the merits of the Sunshine Ordinance order here, which I agree with. But one question I had, and we had last time, was what are the avenues for an agency to challenge an adverse order by the Sunshine Task Force?
Absolutely. There is no appeal process. There's nothing of that sort. There is always, in any public records, public meetings situation, there's always the possibility that people can go to court, go to Superior Court. That's always sort of sometimes a last alternative. Some people don't bother with coming in to the Sunshine Task Force because they don't have to. It's an alternative forum to the Superior Court. But what we can do for people is give them an opportunity to have their cases looked at, and then they don't have to consider the expense of hiring counsel to go into the Superior Court. But a matter that would end up in the Superior Court, it wouldn't be an appeal of any kind. I think it would be simply maybe the judge there wants to hear what the task force did, but I don't see how, in my experience, I don't see how a judge in the Superior Court would really take that into much consideration, because it's not something they'd be bound by in any way. And so it's not an appeal, and I do not think there's any viable way that someone would take some kind of a mandamus on something that the task force does. And I've certainly never heard of anyone attempting to do so. Basically, we make an order. There's either compliance or non-compliance with our order. And after that, the order itself is sort of the last step in the process. We'll try to coax people sometimes to comply with an order afterwards. A lot of agencies do respond to our orders very favorably. We have a good relationship with a lot of the agencies of the city and county. We do spend an inordinate amount of time with maybe 3 or 4, maybe 5 different agencies of the city where we're sort of trying to give them a few more kicks along the way.
And are the task force orders binding or advisory?
They're not advisory. It's my own belief that because the ordinance and Commissioner, you read from 6721, that's really the primary provision, at least with regards to documents, whereby the task force can issue an order. And so the language order is there, and we'd probably issue maybe between 15 and 30 orders a year, order to produce. I think that it's as binding as a lot of orders, but it doesn't have, if you think of a court order, for example, in the Superior Court, that's a binding order, but it also has a possibility of sanctions, contempt, et cetera, et cetera. We don't have any of those things. And so what I believe, at least, I can't always speak for all the other task force members, but I believe that it should be treated as we're ordering them to do it under our authority, whether they decide to. I think there are some folks who just basically they don't seem to care about our orders, but a lot of people do. So there's somewhat of a the more resistant people see that we can't do anything, so maybe they can get away with it.
Do any of my colleagues have any questions?
Mr. Schmidt, are you aware of any non-willful referrals that the Ethics Commission has handled in the past?
The last couple words I didn't hear on your microphone.
Are you aware of any non-willful referrals that the Ethics Commission has handled in the past?
It's my belief that the record might be that they've been handled, but they've all been rejected. I can be wrong. It could be that we go back 15 or 20 years and something happened. That's somewhat of a, it's something where we sort of anticipate at this point that anything we send over to you, it's just going to get kicked back to us. We don't think that's right. That's one of the reasons I'm here. That's one. Our chair is here also, Matt Yankee. He's here also, and we're trying to sort of address that to see what is it that maybe we're doing wrong. We're really concerned more about the willful violation issue. But we're just presenting to you the fact that we think even the non-willfuls could come to you. We're not sure if your structure at the commission is such that you have people who have actually looked at the substance of any of those cases where a non-willful case was brought in. It's unclear to us, partly because even though we are not, we're not overly happy about some of the recommendations that will be on line 6 today. The existing rules, it's somewhat unclear how these matters sort of go by the wayside and get kicked back to us. Sometimes there's this back and forth where we send something to you, we get it back, and then we're not sure if the Ethics Commission has a position that, well, we just will never, ever, ever handle those. Maybe that's what we're ascertaining here in this process. I don't know. But I think that there have been some that have gone through the process, but I really can't think that there's ever been one where there was a finding favorable to a petitioner.
So when you said that they were rejected in the past, you didn't mean that they were refused to be heard or considered. It was that they weren't sustained on the merits?
Well, I think that maybe they were resolved at the level of your staff. I'm not sure, and they may not have come before the full commission, or possibly I don't know if your staff can put something on a consent calendar. I don't know your processes that well. But we're not quite sure how much those cases have been looked at in the past.
Thanks. Yeah, I just want to refocus our conversation right now because we have a particular case before us, and so as I understand it, what we need to do is interpret the written rules that we have currently and apply them in this case. But there are broader issues that will matter for number 6 about that take into consideration some of the policy considerations. I didn't mean to interrupt you, Commissioner. But you have further.
A few questions. So, am I right, Mr. Schmidt, that your position now is that this is not a willful violation that you're referring to us?
I do not. I don't take a position on that. We did not have a finding in our task force. We have to have a quorum vote to pass anything along, and our order was simply that there was a violation, and we ordered production. But we could have added on a determination that we thought there was willfulness. We had that option, but we didn't have a vote saying we find it's not willful. And so for that reason, I don't know if Mr. Lataki should be prevented from coming to you to say that Mr. Lataki believes there's willfulness here.
Do you mean a willful violation of the duty to release records under the statute, or a willful violation of task force order, or both?
A willful violation. I would say primarily a willful violation of the duty to produce, the duty to act, the duty to produce. In these cases, these are all document cases, to produce documents. But I do not want to foreclose the idea, partly because of the way 6735D is written, that an order of ours that's not complied with could be brought by a member of the public to you, and they could ask you, under the language of that provision, and that they could ask you, could you please look at this and enforce this order? Again, as a task force, that's not really our priority. If you don't have remedies that are in addition to ours for this idea of we make the order and then you make the same order as us, but there's no more remedies that you have, I don't think as a task force that's something that we're seriously seeking but we do want to, as we are advocates sometimes for, not advocates, we're not advocates for our petitioners, but we do have, we're very public facing. We do want to have any of the remedies that are in Sunshine, including remedies where someone comes to ethics to assert their rights. We do want those to be preserved, acted upon. And 6735D, again, it's written strangely, but we do think that there must have been an intention under the terms of that matter, of that measure of the ordinance, to allow people to bring things before ethics that are Sunshine related.
Further questions or comments? Okay. We should put a motion on before taking public comment, or take motions first from, I guess Kathy's there, Assistant City Attorney. It's okay.
You can do either. You can
Yeah.
go ahead and put a motion, or you can accept
Sorry.
public comment.
Yeah. Oh, that's right. Okay, thank you. Do we have the representative from the police department, Sergeant Ware, available?
You do, yes. Good morning.
Good morning, Sergeant Ware. Thank you. Do you have any comments you'd like to add or responses to Mr. Schmidt?
No, not at this time. I do not, but thank you.
Okay. Do any of my colleagues have questions for Sergeant Ware?
No.
Okay. Sure. I think the question from the Commissioner was, should we go over the authority of 67.35D?
I would like to really see 6735D, and I'd like an explanation for it.
I can read that provision if you'd like into the record, so I have that here. Or would you prefer to do so, Mr. Schmidt?
Yes. I'm looking at the document which was submitted for this hearing in Lataki, and I do see that 6735D is mentioned early on. However, somehow later in the analysis, only 35A is brought into the analysis. 35A simply gives people a right to go to court. But 35D, it reads, any person may institute proceedings for enforcement and penalties under this act in any court of competent jurisdiction or before the Ethics Commission. If enforcement action is not taken by a city or state official 40 days after a complaint is filed.
Thank you. Let me try to collect my thoughts on this. So, as I understand it, the May 2nd, 2025 referral from the Sunshine Task Force to the Ethics Commission was a referral for enforcement proceedings under that code provision that was just read into the record, Administrative Code Section 67.35, subparagraph D, against the San Francisco Police Department for its failure to follow an order issued by the Sunshine Ordinance Task Force. So it was focused on the failure to follow an order. Section 10B of the Ethics Commission's enforcement regulations provides that if a city officer or employee fails to comply with an order of determination by the Sunshine Ordinance Task Force or supervisor of records, then those agencies may refer the matter to the Ethics Commission for enforcement, pursuant to its authority under San Francisco Charter, Section C 3.699-13, and San Francisco Administrative Code 67.35, subparagraph D. The proceedings last time, the police department acknowledged that it received the Sunshine Ordinance Task Force's order and that the police chief was aware of it and declined to abide by it. There's some dispute about whether or not, who is right on the merits of the dispute about whether the orders have to be disclosed or not, but that, as my view, is not the question before us. The question is simply whether or not there was a willful violation of an order by the Sunshine Ordinance Task Force. And the subparagraphs about administrative remedies under Section 10B provide that upon a finding of a violation, the Commission may impose any of the remedies set forth in SF Charter Section 3-699.13, except that the Commission may not impose administrative penalties. And then there's a separate paragraph for willful misconduct. If the Commission determines that an elected official, department head, or managerial city employee willfully failed to discharge any duties imposed by the Sunshine Ordinance, Brown Act, or California Public Records Act, then the Commission may find that the city official committed official misconduct. Noting that there are significant questions about what the right policy context is here and what our rules should be moving forward, my interpretation of the rules is that we can find there was a willful violation of the Sunshine Ordinance Task Force's order. I would move to make that finding, but I would not impose any penalties beyond making the finding itself. I don't know if there will be a second for that, or if there's another motion, or if we want to take public comment before. Oh, sorry, go ahead. Director Matthews.
Good morning, Commissioners. B.C. Matthews, Director of Enforcement, for the record. I just wanted to, again, reiterate, I had stated this at the last meeting. I think it's really important to note that the matter before the Commission today is not a willful violation issue, and if that's something that the Commission wants to consider, it should go through the regular process. We have a process for reviewing and handling willful violation matters. And just as Mr. Schmidt had said earlier, Mr. Lataki has the ability to request that this matter be heard as such. I think for the Commission to make a finding on willful violation would be an overreach, or at least going beyond the scope. And I just wanted to make that point really clear.
Thank you. I have a question about that because there's a distinction in Section 10A and 10B. The normal process that you're referring to, is that the Section 10A process for
That's correct.
Complaints of, okay. Under, maybe you can help me shed light on this part. Under Section 10B of the Commission regulations, enforcement regulations, subparagraph 5A, there is a section there, a paragraph there that appears to be tied to Section 10B referrals. It's Section 10B 1(5)A, and it's headed willful misconduct if the Commission determines that an elected official willfully failed to discharge any duties imposed by the Sunshine Ordinance, then the Commission may find. So I was reading that to mean that even if something came in through 10B, if we nevertheless found on the record that there was a willful violation, we can make that finding since it's not under the Section 10A process.
No,
a different interpretation.
I see that. I think that's one of the ambiguities of the current enforcement regulations that we are working to address. It's clear that that is a remedy for willful violation. It's, in our view, misplaced, and so there will be a reordering of that, restructuring of that. And I
Thank you.
don't know if
Do we have additional comment from the Deputy City
I
Attorney?
was just going to note, as I did in the last meeting, that you'll want to look as well at the notice that was provided to the parties. The notice provided to the parties here specifically refers back to the referral from the Sunshine Ordinance Task Force, not to any freestanding complaint from the petitioner. And that referral is specific to 6735D for a non-willful violation. Of course, the current regulations provide that a complaint may be brought for a willful violation, in which case it would be handled according to sections 1 through 9, 12, and 13 of the current regulations. Those provide that any member of the public or a commissioner can make a complaint, which would then be sent to the Enforcement Division, handled in the usual way, which would result in the things that you normally see on a hearing where you have briefings by the parties, et cetera. So that would be the process for a complaint under Section 3 of the current regs.
And this is the notice to Mr. Lataki and the police chief?
Notice, and this is in your materials for item 4. There's copies of the notice to Mr. Lataki as well as to other 2 individuals with the police department. It refers simply to the order issued by the task force on October 2nd. And then when you look at that specific order, you can see that it's for a non-willful violation.
Is Sergeant Ware still on the line?
I am, yes.
Thank you, Sergeant Ware. Does your understanding, what was your understanding of the notice provided, and is it your position that there is not adequate notice for a finding for willful violation at this time?
Well, frankly, I'm filling in for Lieutenant Ozel, who participated in the prior meeting, and so I don't have a lot of additional information to offer the commission at this time, other than, I'm just reading the letters that were provided to the requester from one of our attorneys on staff, as well as the chief of police, as to our reasons as to why we were not going to provide the information requested. But other than that, I don't have a whole lot of information pertaining to the prior hearings that were participated in by the lieutenant. Hello?
Thank you. Thank you,
Oh,
Sergeant
I'm
Ware.
sorry. I thought I didn't unmute myself or something. Okay, I'm sorry.
Thank you.
And if I may just add to that, had the referral been clear that this was a willful violation referral, we would not be here today. Dealing with a show cause hearing, it would be an investigation, and if that was found, it would come before you, like the attorney noted, through the regular enforcement process. So, and it's really clear in the referral that was noted. So,
is it your position that, based on what has currently been referred, we should take no action, and Mr. Lataki, if he wants to pursue a willful violation of a task force order proceeding, he needs to take that step directly?
That's correct.
And that has not happened in this
That
process
has not
yet?
happened.
Okay. Given that change in my understanding of how this referral ended up before the commission, I'm withdrawing my motion now. I don't know if another commissioner would like to make an alternative motion on this agenda item.
If I could just speak on this, I agree that, this, if we were to determine that this is a willful violation, that is a big step, and so it would be best if we have some clarity on what the Sunshine Ordinance Task Force position is, or Mr. Lataki's view on this. I think it would be better if we proceeded with a cleaner record, and I think that begins with knowing, given that we've had such a fulsome discussion about how these provisions intersect with each other, it would be better if we have a clear understanding of what's being asked of us. And I think that burden rests on Mr. Lataki and the SOTF.
I would move in light of this different understanding, to take no action on this referral without prejudice to either Mr. Latoki or the task force representing the complaint following the alternative procedures set forth in the regulations.
A second.
I think we still need to take public comment on this item, so I'll call public comment on item number 4. Is there anybody? Thank you.
Hello. Just a few brief public comments. I'm Matt Yankee, chair of the Sunshine Ordinance Task Force. Just to clarify some answers on some of the questions that you asked before. The Ethics Commission has, in fact, in numerous instances in the past, taken action on non-willful violations. I sent you a communication related to, I believe, another item on this agenda, and it links to the historical record. So if, in fact, the position now under the current enforcement regulations, not the new ones, but the current ones, is that you can't do that, that's actually a change in procedure from what the Ethics Commission has in numerous instances done in the past. So I would urge caution before you suddenly say that you can't find non-willful violations, because that has, in fact, happened numerous times. Secondly, I want to just point out an odd issue that we came up with and why this came before you in the way that it did, is that even though we consider willful violations to be more egregious and more serious, they don't, in fact, get before you. They only go to staff. And only if staff releases that to you will you ever even know about it. So we had referred to over before this one, as Member Schmidt discussed, as willful, and one of which has, I think, been pending for over 6 months. We still haven't heard back. The other was dismissed after more than 6 months. So we decided to refer this one over so that you, as the appointed commissioners, could actually take a look at it. So whether or not it was willful or non-willful wasn't much of the discussion we had. It was more of how can we get matters in front of you, since we felt that the willful ones were not making it through the process and getting the attention that we felt was necessary. We could talk more about that later when we get to the enforcement regulations, but I just wanted to bring up those points. Thank you.
Thank you.
Before you move on to the next commenter, I do just want to point out that the last commenter is incorrect, that dismissals are not presented to the commission. The enforcement regulations actually do require that every case closure and dismissal is sent to the commission, and we do that. As you know, you get an email regularly from the Director of Enforcement with a full list and write-up of all the dismissals and closures, so you do have that information. So you're fully aware of all of the cases, including willful violations, that the Sunshine Ordinance Task Force sends to the commission.
Thank you for the clarification. Are there any further members of the public who would wish to make public comment in person today? Seeing none, Mr. Clerk, is there anybody on the phone?
Checking to see if we have anybody in the queue, and Acting Chair Salahi, we have 2 people in the queue.
Please proceed with calling them.
Caller, are you there? Caller, are you there?
Hello, can you hear me?
Thank you. Caller, your 3 minutes starts now.
Hi, good morning. This is Mr. Lataki. I apologize for not being able to attend in person today, but I'm disappointed that I was not recognized as appearing remotely and not able to participate in this display. The language of the Sunshine Ordinance calls the task force's orders of determination orders. The drafters of this ordinance would not use that language if they're meant to be advisory. The fact that the task force, or even the Ethics Commission, does not have great remedies for noncompliance does not change that there's still a required duty. Whether the task force referred the matter to the commission as willful misconduct or not, facts of this case in front of you clearly show a willful violation of the order of determination. So if the commission believes that complying with orders of determination are in fact required duties under law, then this should proceed now under Section 10A of the commission's enforcement proceeding. I don't believe that I should be required to re-refer the matter that we've been discussing past 2 meetings. Thank you.
Thank you for your comments.
you hear me now?
Yes. Next caller, your 3 minutes starts now.
Great. Good morning. This is David Philpell. Sorry I'm not a member of the Sunshine Ordinance Task Force, but speaking, I think, as an individual. I hope my comments at your June meeting were helpful. I was not planning to discuss deference this morning, although that did come up in one of the earlier discussions. There is a history of task force referrals to this commission, both willful and non-willful. Chair Yankee referenced that a few moments ago. This matter is about an underlying violation of the Sunshine Ordinance as determined by the task force and expressed in an order. It's not really about non-compliance with an order, just that triggered the referral under 67.35D and current enforcement regulations, section 10B, which contemplate this hearing, public deliberations, and findings, and available remedies. While section 67.34 discusses willful, section 67.35D does not. I think the record here is clear. You have evidence before you. You have testimony from all parties last month and today. This is a referral of a non-willful violation. It's properly before you, and I would encourage you to act on that, make findings related to enforcement under 67.35D, under the existing regulations. I'm happy to take any questions, and I think you have a number of parties that can answer further questions. This has been a good discussion, and I appreciate it very much. Thanks for taking the time.
Thank you for your comments.
Sorry, am I permitted to ask questions of Mr. Yankee or Mr. Schmidt?
If the commission would like to ask further questions, I would also note that it seems we see now that the petitioner was in attendance virtually, and since you did recognize a representative for the SFPD, you may wish to recognize him and provide an opportunity for you to ask any questions you have, or for him to provide further statements as a party to this proceeding and not just a public commenter.
If Mr. Latoki is still on the line, do you have further statements or comments you'd like to make? And do any of my colleagues have any questions they'd like to ask of him?
I guess, Mr. Lotaki, can you, just so the record is clear, articulate whether it's your view that this is a willful or a non-willful violation, just so we're clear on your position?
Commissioner Ye, I believe he's not on the line anymore.
Hi, good morning. Thank you.
Morning.
I do believe this is a willful violation of the order of determination.
Okay.
Hi, I'm sorry. You hear me?
Yes, thank you.
Thank you.
Thank you. But Mr. Latoki, you did not file a complaint directly with the commission, is that correct?
No, I did not file the complaint directly.
Okay. You may very well be right, but the referral before us now is from the task force under a different provision here. So I don't think that we have a complaint directly from you on that we can consider at this point in time, but you could present that in the future. That said, it seems like we do have the option to make a finding of a non-willful violation without any penalties that would be attached to it. So if there is anyone who'd like to make a motion to that effect, the floor is yours.
So could I ask a question of Mr. Yankee and Mr. Schmidt?
Yes.
Okay. Mr. Yankee, you mentioned submitting a comment identifying past instances of non-willful referrals. Can you point me specifically to what you're referring to? Because
Sure.
I see the letter.
Okay, so you see the letter. If you click on, let's see here, there's a link to a packet that was included in that discussion.
The minutes?
Not the minutes, the other link. And I'll try to pull it up to walk through it with you here. It's the one that says Binder 1 PDF. And if you go to Appendix A, this was just at the time. Obviously, this was in 2014. This is not a full comprehensive over decades, but nonetheless, this was a review at the time of past referrals that made it over to ethics. And if you go to Appendix A, which appears to be on PDF page 12, there's a chart that Ethics Commission staff prepared at the time listing various complaints that were sent over, and then the summary of disposition column. And you can review that, and you can see that there's instances where they did or did not find willful or non-willful violations.
Can't find it either, actually. Yeah.
Neither of us can find it, so do you have a copy now or something we can look at?
If I can, I could try to walk you through it. I mean, I have it on my phone. I don't have a paper copy of it. It doesn't appear that my email or the attachments were included in this packet here that's printed. If you take a moment and go to this is the, if you look at your past meeting minutes, this would be for the.
Was that submitted in connection with this hearing or the prior one?
This was submitted, in fact, with item number, it's later on this agenda, the one about
item number 6. Oh, it's part of that comment.
Yes.
Oh, okay.
Yes, but it does include this chart that was included. Obviously, I was making comments in that one about concerns about the change in direction, which is why it was included there. But
so this is in reference to the December 16, 2014 meeting, is that right?
Correct.
Okay. I just don't have the attachments. And
do you have the email that I sent to you?
I'm looking for it right now.
Okay.
Yeah.
Because it's one of the hyperlinks that was included in that email. It's not an actual attachment to it. It's one of the links in that email.
Yeah. So speaking for what I have in my inbox, I have a forwarded email from you to the commission. I don't see attachments to the email.
Right. So if you scroll, it's a hyperlink. It was a very large attachment.
Okay.
So if you scroll,
yeah,
3/4 of the way down,
Binder
you'll
one.
see
there's two.
Okay.
There's two.
Yes.
There.
So it's that first link. If you click that first link.
Thank you.
And what page are we looking at?
Then it will go to PDF page, looks like it begins on page 12 is where the appendix begins. Then if you look at the summary of disposition, you can see there's obviously a variety of ones that were referred over as willful or non-willful, and actions that the commission took that found violations or did not find violations, but they certainly did make findings of violations that were
okay. Can you point us to an example where the commission did find a non-willful violation?
Sure. So PDF page 13, complaint 04, it's the middle one, -120507. The commission found that respondent Caroline Salayak, custodian of records for the Municipal Transportation Authority, violated 6725, the Sunshine Ordinance, by failing to respond in a timely manner to an immediate disclosure request despite reasonable efforts to timely comply. Certain documents were provided. The commission also found that respondent did not violate 6721C or 6721E of the Sunshine Ordinance. So the commission has obviously parsed through these on past instances. Another one, if you go to the next page, there's 02130-307. Commission found that respondent Kate Patterson, San Francisco Arts Commission, violated Section 6725 of the Sunshine Ordinance. So there's multiple documented instances of this. And these would be under what your current enforcement regulations are. So in this instance, the underlying violation is a violation of Administrative Code 6721, the case currently before you.
Just moving on to a slightly different topic. I know this issue came up in the last hearing, and I can't remember what exactly was discussed, but is there, I guess, a couple questions. Is there any reason why the task force doesn't just avail itself of the courts? What remedies can we provide that the courts cannot?
That's a good question, and one that we would like to know the answer to, and perhaps this exercise will help bring that to light. Obviously, if you look through the Sunshine Ordinance, our actual enforcement powers are mainly making referrals. So we're not an expert in what you can and cannot do. I would explore, obviously, I would urge that you explore every possible opportunity under existing law to find ways to enforce this, and perhaps there isn't one. And if that's the case, maybe that shows a problem that we as a larger city need to resolve, where there's administrative processes, but then nothing ends up happening. The challenges, and I think one of you brought this up earlier, you asked about, well, how can a department appeal this? And the problem is there is no appeal process for the department. If the department doesn't want to comply, they largely just don't. And then it's up to the initial complainant, who perhaps was even the prevailing party, to then spend money to go to Superior Court and hire a lawyer and go through that process. And so we're looking for a way that this process can play out that doesn't put the burden of monetary, I don't want to say penalties, but monetary issues on the complainant, who's actually the prevailing party. It seems odd that the respondent, the city department, can essentially just do nothing. And so we're looking to have you folks explore that with us. And it might be you just finding the violation as well at this point under what's currently available. I think even the respondent feels that at least that's another body that looked at it. I realize it's redundant and it could be better, but at least it's something. And perhaps, if it goes to court, having two instead of one city bodies ruling in favor may help bolster their case should it make it to court.
Thank you. Does anyone have further questions?
Yep.
Yeah.
If I could just add on that, the task force doesn't have any ability to take anything to court, and it doesn't have the ability to put people's cases before the court. That's something that a claimant would have to do all by themselves. They'd find their own lawyer, et cetera. That's just not, it's never been, maybe it's been proposed, but it's never been tried, and there's no authority for something like that. So the whole court option is just completely an alternative that someone has to using the city's processes that they can choose, but at their cost and peril.
Mr. Lataki could go to court, is that right?
Mr. Lataki could absolutely, he could have gone to court before coming to the Sunshine Task Force. He could have gone to court before coming to the Ethics Commission, and he can go there now. And so there's nothing preventing this from going to court. I think that the intention of having these process is as an alternative to having to go to that amount of trouble, that amount of time and expense, et cetera, something that's much more expedited to come either here or to the task force.
So I acknowledge that core processes can be expensive and cumbersome. It just seems to me, at least at this moment, and I will also confess to struggling a lot with the issues that have been presented, is that it seems like, given that there's some dispute about our jurisdiction, our abilities to handle this matter, that the court route seems to be cleaner and clearer. So maybe that's just the more preferable route, where authority is clear, whereas here we're still debating about fundamental issues of what we can and can't do, what's presented to us and what isn't presented to us. And I feel like that in itself has, is time-consuming, resource-intensive. So that's just a thought.
I see your point exactly, that the court could take this and they know exactly what to do with it. And in fact, historically, many cases do go to court. A lot of these, I'll call them First Amendment matters, they're brought by large newspapers, media organizations, et cetera. So that option has a lot of favorable aspects. I guess our position is that the Sunshine Ordinance, it was a voter-approved ordinance, and it assigns to us as a task force, and it does assign to the Ethics Commission the obligation to make an alternative remedy available. And so we may not be able to do as well as the courts could do, but I think that we're just sort of talking about how can we do that in our respective roles.
Thank you all. Any further questions?
Yes, I have a quick question. If the officer is an employee of City and County of San Francisco, wouldn't the City Attorney's Office represent him?
I can't absolutely 100% speak to that, but I think as a general matter, that is how it's going to work, is the City Attorney's Office is going to generally represent any of the officers, employees, whether it's in litigation or we don't have the city attorneys come in before the task force as counsel in that way, but I know that people get advised by the city attorney's office. And I'm sure you see city attorneys coming in representing people from the city. And so, yes, there is an attorney available to the city official or the city employee who's accused of a violation. Yes.
All right. Any further questions? Okay. Thank you both, and thank you to everyone who's offered their views today. I don't think I changed my motion. It stays the same, to take no action on the referral from the task force, but without prejudice to Mr. Lataki presenting a complaint for a willful violation, or the task force doing so itself if it wishes to do so. My reasoning for that, it's primarily driven by the questions about our jurisdiction over non-willful violations, but also our inability to do much with that if we find one about non-willful violations, and the recommendations of our enforcement staff to go through the normal procedure for willful violations. I don't view the issue here or the general issue of the relationship between the task force and the Ethics Commission as being one regarding whether we have the ability to order the disclosure of records or decide whether or not they are public records that are required to be disclosed. But I view it more as helping the task force identify misconduct by city officials who don't follow task force orders. I view them as two different things. And going back to the conversation earlier, in some ways I think of the rent board as an analogous thing where a tenant can go to the rent board for relief or go to small claims court or superior court. But you want both sets of orders to be followed by whoever the governed, regulated population are. So are we ready to take a roll call on the motion that's pending?
Yes, you would either take a roll call on that, or if you want to entertain amendments to that motion.
Okay.
But you wouldn't take further motions at this point.
Okay. Should we restate the motion just for clarity? Okay.
I think that'd be helpful.
So my motion was to take no action on agenda item number 4 without prejudice to Mr. Lataki or the task force presenting the issue as a willful violation allegation. And was there a second?
I'll second.
On the motion to take no action on number 4, I'll call the roll. Commissioner Ye?
Aye.
Commissioner Francois? Aye. Acting Chair Salahi?
Aye.
With 3 votes in the affirmative, the motion passes.
I now call agenda item 5, hearing on the merits in the matter of William Walker, case number 2223-507. This item is being called in connection with an ongoing enforcement matter involving respondent William Walker. On March 5th, 2025, this commission ratified the executive director's probable cause determination as to all counts of violations of law against respondent. Because we have not appointed an individual hearing officer, the commission as a whole will serve as the hearing panel for this hearing. As acting chair, I will assist in the administration of the rules and procedures of this hearing. First, I need to ascertain if Mr. Walker is present for the hearing. Mr. Walker, if you are here, can you identify yourself, please? Would we be able to see if there's attendance through the telephone? Or is that?
Checking the queue to see if he's calling it. One moment, Chair. No callers in the queue.
Thank you, Mr. Clerk. The respondent in this case, William Walker, is not present for this hearing to proceed. Would the Enforcement Division like to address the respondent's absence?
Good morning, Commissioners. Once again, BC Matthews for the record, Director of Enforcement. Yes, at this time, we would like to move for a default order on this matter. The matter before this commission is very clear. The 6 violations, the 6 counts that have been presented. Mr. Walker does not dispute violating these provisions. There's no dispute at all, and he's not here. So really, the matter before you that you need to consider is just the penalty that should be assessed. And we also have a proposed order that I can present. We have a specific penalty amount that we are requesting. On each count, we request that this commission fine Mr. Walker $500 per count for a total of $3,000. We also request that this commission order Mr. Walker to comply with these requirements. These are important disclosures. It is important for the public to know what is being spent and how much, and the money that is involved in political campaigns. These disclosures are important for the public's interest. Mr. Walker has completely disregarded his obligations, and at this time, we think it's important because just assessing the penalty, it is important, right? It's to partly hold him accountable, but Mr. Walker has suggested that he does plan to run again in the future, and it's really it's important that that we have that order in place so that if he comes, it likely will come back before this commission. At least we can have that as an aggravating factor too. And one second, I just want to grab my notes so I don't forget anything. And if you'd like, I can recite each count, but I don't know if you think that's necessary.
I personally don't think that's necessary because it's in the record. Do any of my colleagues want to hear that on the record? Okay.
But I can present the proposed order to you.
Yes. And yes, please. Thank you.
Let me just see if I think that's all I have.
Okay.
Okay.
I have some questions just about the request for a default judgment. I want to confirm how notice was provided to him of the hearing and whether what the most recent contact with him was, given that there was some sporadic engagement throughout the process from him.
Right. So Mr. Walker was provided notice of this hearing. Bertha, do you want to? Give me 1 second. I'm going to pull up my hearing brief. I want to get the exact dates that he received notice of this hearing. Okay, so Mr. Walker was received notice of this hearing on July 11. Excuse me. He received the notice on June 3rd by the executive director, and he was duly noticed. After the email went out to Mr. Walker, the Enforcement Division also called Mr. Walker to follow up to ensure that he received that notice. Mr. Walker has acknowledged receipt of that notice. We also had follow-up conversations in an attempt to resolve this matter, even following that, and also on how to proceed in terms of admitting exhibits and probably stipulating to some of those exhibits. So he was fully aware that this hearing was scheduled for today. And Mr. Walker did not notify us, inform us that he would not be here. In the past, Mr. Walker has let us know that he'll call us a day before to let us know if he's not unavailable, and we did not hear from him.
Thank you for confirming that. So there's no, you're not aware of anything to suggest that there might be a reason for his absence?
I'm not aware, and I will. Okay. I did not receive any notification from Mr. Walker.
Thank you. Do I hear a motion to issue a default judgment against the respondent in the matter of William Walker? Counts 1 through. Pull that up.
6.
6. Thank you.
May I show you the proposed order?
Thank you. Is this the same one in the binder?
It should be, yes.
Thank you for your patience. So my view is that the allegations are well substantiated by the supporting evidence, so we would be able to find a violation even without a default, assuming the allegations are true. So I feel comfortable moving for presenting a motion to issue a default judgment against the respondent in the matter of William Walker on counts 1 to 6. Is there a second?
I second.
Thank you. Clerk, on the motion to issue a default judgment against William Walker on counts 1 through 6, could you please call the roll?
Certainly.
Excuse me.
I'm sorry.
I think we should have a public comment.
Yeah. Thank
since
you.
We hadn't earlier.
We'll take public comment on this matter. Is there anybody in the room who would like to make public comment? Seeing nobody, is there anybody in the call queue?
Vice Chair Salahi, there are no callers in the queue.
Okay. That closes public comment on this item. Mr. Clerk, can you please take the roll on the motion to issue a default judgment against William Walker on counts 1 through 6, please?
Certainly. A motion has been made and seconded to issue a default judgment against William Walker on counts 1 through 6. Commissioner Ye?
Aye.
Commissioner Francois?
Aye.
Vice Chair Salahi?
Aye.
With 3 votes in the affirmative, the motion passes.
Thank you. Having issued a default judgment on counts 1 through 6, the Commission shall now vote on any penalties to be imposed against the respondent in this case, William Walker. The recommendation from the Enforcement Division is to to assign a penalty of $500 per count, and the Enforcement Division's briefing on this discusses comparators as well as the factors that would support that. Do I hear a motion from any commissioner to impose a penalty of $3,000 or some other amount as requested by the Enforcement Division in the hearing brief and the motion for default judgment?
So moved.
And to be clear, that's for the $3,000 penalty?
That's correct.
Any seconds?
I second.
Do we need to take public comment again on this motion?
I think we should just
Yeah.
to close the loop.
With the motion pending, we'll take public comment on the question of the penalties to be assigned. Is there anybody in the room who'd like to make public comment? Seeing nobody in the room, Mr. Clerk, is there anyone in the call queue?
Checking the queue, and there are no callers.
Thank you. In that case, can we please take roll on the motion?
A motion has been made and seconded to impose a penalty of $3,000 against William Walker. Commissioner Ye?
Aye.
Commissioner Francois?
Aye.
Vice Chair Salahi?
Aye.
With 3 votes in the affirmative, the motion passes.
Thank you. I now call agenda item 6, discussion and possible action on proposed amendments to the Ethics Commission's enforcement regulations. Director Matthews, would you like to present for the Enforcement Division?
I hope you're not tired of hearing from me today, because
Not at all.
this might
Never.
be another long one. I'd like to just offer you the current enforcement regulations in print, because I'll go through the red lines, and I want you to be able to view them side by side. I think it'll be easier. Yes, they're all the same, one for each of them. And my colleague will be helping with the slides today. So, Eric Willett, thank you. I don't know if we have those ready to go, but anyway. So today, for this agenda item, I'll be providing you with an update on the efforts of the Enforcement Division to update the enforcement regulations, and we'll walk you through a draft of our proposed amendments. For the purpose of this presentation, I believe a more efficient way to address any questions or input that you might have would be to do so section by section, because we have a lot to cover today, and it'll be much easier to just at least attempt to resolve them as we go through them. Also welcome your thoughts on how you'd like to proceed at the end. Seeing that.
Apologize for interrupting you. I just
Sure.
wanted to cover. Are we supposed to have red lines, or is these just the current?
No, so the red lines you
that's-
see.
okay, thank you.
And you should also have, for the agenda item, you should have the red lines.
I don't think it was a
It-
red line. It looked like maybe a final copy, but it was a clean copy. Is it the same red line
There's a
as?
copy, yeah, this document for agenda item 6 should be. If you have all the agenda items printed, I'm not sure if you have. If you don't, I can. I mean, you'll see. I have everything.
Is it the same? Is the red line exactly the same as at the last meeting? Because I have a copy of that.
It should be.
changes.
There might be one change, but not major. Yeah, for the most part, yes. I'd say 99%.
Yeah, and I can see that the materials posted online do include the red line, so that may be just an error in your binders.
The mailed copies, I think, were clean copies, but it's okay.
I can
Oh,
offer mine. I don't quite need here because I think it's helpful for you to have it. Hopefully, I won't regret that. Do you have one? I'm sorry, I assumed you had them, so I only printed the other one. I can.
If they're on the website, I can pull that up, yeah.
All right, I'll move along because we're, okay. So I was saying that I welcome your, obviously your thoughts on how to proceed, but my recommendation, since we don't have all 5 commissioners, would be to hold off on any action today, but just give us feedback and answer any questions. But if there are any clear areas and you feel comfortable moving forward, I'm open to that as well. Okay, so slide 2. The purpose of this project was to review the enforcement regulation, identify areas of ambiguity and inconsistencies that require clarification, and to adopt changes to the regulations that would strengthen and ensure a fair and more efficient enforcement process. That work has included conducting best practice research across peer enforcement agencies, consulting with City Attorney's Office, and engaging interested parties to seek their input and incorporate relevant feedback. And I just want to commend the efforts of now Deputy Director Zach D'Amico and Senior Investigator Bertha Cheng. They worked really hard on this project. Our overall goal here is to promote a clearer, more consistent, fair, and transparent enforcement process. And just a quick historical overview, I think this is important. The enforcement regulations were originally implemented on July 5th, 1997, and most recently updated on March 19th, 2018. Since that time, the Enforcement Division has expanded in both size and capacity. And in recent years, the division has seen a growing number of cases proceed through the probable cause process, including moving 2 cases through a full hearing on the merits in the last year and a half. As we've demonstrated a greater willingness and ability to advance cases through the PC process, particularly when respondents decline to settle or engage in delay tactics, we've also experienced a corresponding increase in such cases moving through the process. And following some of the cases that we've had in the past, staff worked to, and the issues that we started to identify with the enforcement regulations, so staff worked to develop first the enforcement hearing guidebook that has guided us so far in the process, but in the guidebook, all we did was make recommendations. Here, we're hoping that we can actually adopt some of those recommendations that have been made and address other issues that have been identified. So last year, we focused our efforts on reviewing, and now we're here. There were 4, next slide, slide 4. So there were in total 4 interested party persons meetings today, held for this project. The first round took place on March 4th and March 6th, and the second round took place on May 27th and May 29th of 2025, excuse me. 4 participants, including legal practitioners from firms who represent respondents, attended the first round, and they expressed general support for our recommendations. They obviously provided some feedback, especially regarding the importance of ensuring that our investigative process is not unduly prolonged, and that due process be ensured for every stage, particularly in light of the proposal to allow the reopening of matters in certain circumstances where new facts are discovered. Participants also emphasized the need for legal clarity, again, to ensure procedural fairness for all parties. The second round of interested persons meetings was held to gather feedback on additional proposed revisions that were not addressed at the first round. For this round, we had 5 participants, including members from SODIF, Chair Matt Yankee, and Mr. David Pilpel were in attendance, and there was a great discussion focused primarily on pretty much everything that you've heard in the last meeting and today about the provision and the authority of the Ethics Commission regarding the Sunshine Ordinance. And regarding the overall proposed amendments, the feedback we received across both rounds of IP meetings reflected broad support for enhancing statutory clarity, reinforcing the Commission's role in addressing serious violations, and strengthening procedural safeguards to bolster public trust in the enforcement process. We also conferred with the City Attorney's Office to ensure that our recommendations are legally sound, and their insights have been instrumental in helping us present these proposed amendments to you today. So at this point, I will walk you through each proposed amendment section by section. Hopefully you have a copy of the current regulations, and you now have access to the red lines so that you can follow. Okay. All right, so this first proposal is regarding Section 2F. So the section that I will mention really is the proposed section, not to confuse you. But currently, the regulations do not provide for an extension of the deadline for submissions that fall on a weekend or a holiday. So this proposal just clarifies that if a delivery deadline falls on a Sunday or a legal holiday, that parties may submit on the following business day. This aligns with regular procedural practice. Any questions on this one? Okay. And of course, take comments later, generally. All right, next slide. So this is 2H. Portions of the regulations refer to good cause, but there's no clear definition. So this provision introduces, this is a new one, introduces what we believe is a clear definition for a good cause.
This, I'm just trying to wrap my head around what the good cause test is used for. It's like extension requests, what waivers, what's the, yeah.
For sure. So we have other sections within the regs that require that if parties have a need to request extension for deadlines, it has to be for good cause, but it hasn't really been clear what that means. Obviously, it's been looked into, and respondents and parties have been able to get responses. But we just think it's important here just to be clear what they should know what that means, right, and what they're requesting. And because those deadlines are important to move our processes forward.
Do you want to hear reactions at the end, or?
I'm open to however you okay. want to do this. I just, I'm happy to keep going for sure. Okay, so next slide. So this is for, this covers current Section 3F, withdrawal of complaints, and this proposed amendment will move the current provision from Section 3 to Section 4, which provides that the Commission may continue to investigate a complaint even if the complainant withdraws the complaint. This one is just sort of reorganizing. 3A Sections 3A to 3E in the current regulations provides a list of complaints filed by a person or an entity. However, the current provision does not fall, we don't think it falls within any specific category of complaints that are filed. So we think it's just better to reorganize this one and move it over. This is more of a real simple reorganization and restructuring. It amends the language a little bit, just to clarify, but nothing too major here. I'm happy to keep going.
Thank you.
Okay, so next slide 9. Section 4E, report to the commission, which is current section 4D. This one is an amended proposal. The proposed amendment will provide a clear, oh, excuse me. No, I'm sorry. This is not, my notes are clear. Okay, so this one will just clarify the, that the enforcement director, me, will provide your reports on a quarterly basis rather than a monthly basis. This is just to align with our current practice because I do provide you my report on a quarterly basis, so we're just clarifying that. And I'll talk about the other deletion. I can't, sorry. Actually, I should look at my red line here. But that's the major revision in that one. The whistleblower retaliation provision, I guess I should talk about that too. I incorporate that in my quarterly report. We don't believe there's a reason to have a standalone requirement for that, so that's why that's deleted, and it just clarifies that process. I can keep going if you don't have any specific question about that.
Just a question about the effect. So does that mean that rather than being provided a report about the status of all complaints, we would hear about them if they're dismissed or if they've been pending for more than 90 days in the quarterly reports? Or?
So I should really clarify. So I provide you with my quarterly report, but around that time, I also provide you with status of closures or dismissals, and that report includes whistleblower complaints, all of the complaints that we get. So you will be getting, you have been getting those, and so we just want this to align, the language of our regs to align with our regular practice.
Okay, thank you.
All right, next slide. All right, so this one is about reopening a case, proposed Section 4F, final decision and reopening of a case, and this is current Section 4E. This amendment will confer on the Commission the ability to reopen, so this is a new one, confer the ability to reopen cases upon discovery of new material facts or evidence, even though the cases were dismissed or closed. The ability to reopen cases by the Commission would be limited, however, by certain parameters that we have outlined in the proposed language, and would also be subject to the 4-year statutes of limitations prescribed under the law. Currently, the regs state that a dismissal or closure of a matter is a final decision on such a matter and represents the end of the administrative process. So we want the ability to be able to review matters if, again, under the stated parameters, newly discovered fact or newly discovered material fact or evidence come to light, newly discovered fact or evidence were in the actual or constructive possession of the respondent and were fairly encompassed in requests for information or subpoenas to the respondent, and staff had no reasonable means to discover this fact or evidence except through disclosure by the respondent, and the facts or evidence, if available, would have altered the outcome of the case. We think it's really important that we have the ability to revisit matters if these factors exist.
And is it fair to understand that as primarily covering if somebody's withholding information or evidence that would have made a difference?
That's right, exactly. And that's why we think number 2 is important to include, right?
And just out of curiosity, has this been an issue with past, have we had cases that were closed that we later regretted because we, yeah.
there's always those cases.
Yeah.
We think it's important to have this. I think it will really help our enforcement process.
Okay. So it's prompted by problems that have arisen in the past.
Does anybody want to add to that?
I just want to be clear. I'm not asking to specifically.
No, I
identify.
think it's a valid question.
Yeah.
Off the top of my head, I'm not recalling any specific case, but I know that we've had conversations, especially going into this, and those discussions came up. And yes.
Okay.
I also don't know that if I would be at liberty to even disclose such a case, because it would have been closed internally. You would have seen that internally, but it would not be for a matter of public discussion either. Okay, slide 11. So proposed section 5C for 3 withholding. The proposed amendment will allow the commission to bring a charge for withholding under sections 1.170F, 2.136A, and 3.240A of the Campaign and Governmental Conduct Code in any case brought before the commission if the respondent does not comply with the subpoena. Under our current provisions, the only option for a respondent's refusal to comply with the subpoena is for the executive director to request the city attorney to petition the Superior Court for an order compelling compliance. However, because the code has a withholding provision, the proposed amendment will clearly include this option within the regulations. We already have that provision within the code. This is nothing new, but we just want it to be clear within the regulations that we'll be able to hold folks accountable if they don't comply with subpoenas. Slide 12. Proposed and current section 5D, confidentiality. This proposed amendment will clarify that evidence obtained through the course of the investigation, including those obtained prior to a probable cause determination, may be introduced as evidence or as an exhibit for a hearing on the merits, and thus may not be subject to confidentiality provision. In practice, this is pretty much how it's done, but we, again, a lot of what we're doing here is really to just bring clarity to our process, so that we don't have to spend 2 meetings asking what we can and can't do. The current provision appears to deem evidence obtained prior to probable cause determination as confidential and prohibit the disclosure of such evidence even during the course of a hearing. We don't believe that that approach, that's not how it's done in practice anyway. Okay, sorry, I hope I'm not boring anybody yet. Slide 13. Okay, so for this one, proposed section 5E, place of delivery. This proposed amendment would relocate the provision regarding place of delivery and just help clarify the process. This is nothing new. We're just repositioning this one just so that the flow of the provisions within the regulations are clearer, and it would, yeah, it's just reorganization. Oh, and an additional amendment, I should note for this one, an additional amendment that will be included that's not reflected here is a gender-neutral language in line 3 where it says his or her. That would say whenever these regulations require delivery to a respondent or respondent's committee. So that's something that we plan to update that's not currently reflected.
Is there an extra by in line 4 in the middle of E? Will be effective and sufficient if made by as set forth. I think, is that by extraneous maybe?
Whenever, what line? Line 4?
Line 4.
Okay. Whenever these regulations require delivery to a respondent or his or her committee, delivery will be effective and sufficient if made by. Oh, right. So we'll cross that out too. That's right. So that will be deleted as well. Thank you. And these are the kinds of edits that we can do here. Okay. Slide 14. Okay. For this one, aside from substantive changes set forth, this amendment would essentially just single out the case closure provision. That provision was subsumed under current Section 7A. Again, just to align with our proposed amendment under what would now be, I think, 4F above. This is just a realignment. Section 6. Give me a second. Oh, okay. And then, let's see. It would also incorporate relevant amendments made under the new 4G, which confers on the Director of Enforcement the ability to reopen the case. We talked about that. And the current enforcement regulations incorporate the closure of cases as part of the probable cause process proceedings. We do our case closure different in practice, and so we think it's important to remove this provision from where it currently exists and just have it as a standalone to align with our current practice for handling closures. Closures come at the conclusion of investigation when the Enforcement Division does not intend to initiate probable cause proceedings. In the past, the Enforcement Division would memorialize a case closure in the form of a no probable cause report as part of the probable cause process. That doesn't happen in practice. If a matter comes before the Director of Enforcement for probable cause proceedings, he can make that finding, and that would just be different. So we just wanted to clarify our regular investigative process for this one. Okay. Slide 15. Proposed Section 7A, initiation of probable cause proceedings and delegation of probable cause hearing officer duties. Current Section 7B1. The current provision delegates Commissioner authority regarding conducting probable cause conferences to the Executive Director and allows the ED to make recommendations regarding probable cause. This recommended amendment will confer on the Executive Director the authority to make findings rather than recommendations. So in practice, currently, after the PC process, the ED sends you his findings, his recommendations, and you have 5 days to decide whether you want to ratify. We're asking to essentially, and we'll get there in the ratification section, but this is sort of part of that conversation, that the ED has authority to make the findings because parties will still have the ability to fully present the matter before you. You will see all of the exhibits, you will hear all of the facts, and we don't believe this would be prejudicial in any way to anyone. Instead, it will help streamline our enforcement process. And we're seeing a lot of cases move through, and we just think this is one way that we can make things go more efficiently. 16. So for these two, we're just capitalizing the word because so earlier we had the definition. This is where you see that appear, and we just capitalizing that. And then there's a gender neutral language as well for slide, so that's slide 17. Moving on. So slide 17 is just aligning our language to ensure that it's gender neutral. And then slide 18. This is proposed section 7C1 and 2, Executive Director's probable cause determination. I just touched on that. Again, conferring that discretion and authority to, oh, excuse me, sorry, this is a little slightly different. So for this one, this will confer on the Executive Director the discretion to delegate the drafting of the probable cause determination to the Director of Enforcement. The current provision provide that the Executive Director will draft the PC determination upon making a finding. However, based on our recent experiences with, these cases moving through our process, we believe that in certain cases a PC determination may mirror a probable cause report to a considerable extent in terms of findings of fact and conclusions of law. There's just no reason. I think there's two issues here. First, the drafting of a whole new report and findings, right? The Executive Director does not need to expend all that time and resource to do that. He can sign off on the PC report and just note that he finds a PC. Or if, in fact, there's additional facts that come in during the conference that need to be included, the drafting of that could be delegated to the Director of Enforcement, and then the ED can just sign off on that. So that's what, but I would say that there's going to be some more work into that language just to clarify that. So I'm not even prepared to ask that you take action on this one, because I think we need to just clarify the two recommendations. Is there any question just about the PC process so far and the proposals? I can keep going. We're not quite done with that. Maybe I should get through section 7 and then.
Sure.
Okay. All right, 19. So proposed section 7C3, findings of no probable cause. First, this will consolidate the current sections 7D3 and 7D7, as they both concern commission's finding of no probable cause. In addition, the consolidated provisions would more clearly delineate the steps required following a finding of no probable cause. The current provisions splits up those sections I mentioned in relation to the meaning of a finding of no probable cause by the commission and the finality of the finding of no probable cause. Excuse me. This proposed amendment will address the misalignment of the two sections by combining them into one section. Also, the current provision does not clearly describe the steps following the commission's issuance of the findings of no probable cause. The proposed amendment would clarify that upon an issuance of a finding of no probable cause, the case will be closed internally without proceeding to the commission. Again, this is pretty much already the practice of the way our process works. Especially because of the charter provision, the confidentiality provisions within the charter, that matters have to be closed and certain records cannot be disclosed prior to finding a probable cause. So we just want to clarify that in the language of the enforcement regulations, and that no further action will be taken by the commission to review or investigate allegations contained in the complaint. This will also be different from when a case is closed. We're not going to be, I don't believe our plan is to reopen a case after there's been a finding. There are some concerns about the finality of our process, right? And so we wanted to just clarify that in this case where there has in fact been a finding of no probable cause, it ends there. That's different from when there's just a closure internally before we get to the PC process.
So just to be clear, previously we would decide if there was no probable cause if it came to us through a report.
So the ED would hear the PC proceedings, and he'll make that determination, and you ratify that. That's how that would go.
And that was, but that's only for a recommendation of finding probable cause, not the opposite.
Right. So if his finding is a no PC, so that's what we're trying to clarify, right? Like, how would that go? What do we do with that if the ED finds no PC? And this is our recommendation of how to handle that.
In our current practice, that does not come to us unless we had affirmatively requested a review of that.
Right.
So our
and we also
sorry.
Yeah, it doesn't come to you. It goes, but you will see the report in the closure and dismissal summaries. You would see that. That's right.
So this would solidify that there is no route to challenge a no probable cause finding
By
through the commission.
That's right.
For a complainant, they'd have to go directly to court.
Right, for a complainant too. That's correct.
Yeah. Okay.
That's correct. Yeah.
And then the first sentence in that red line here, is that supposed to say the executive director's finding of no probable cause is a final decision?
I had that question as well.
Yeah. So then it will be closed without proceeding to the commission?
We could say that. It's the executive director represents the commission, but for clarity, I'm open to making that.
I think it might be clear just because the next paragraph talks about proceeding to the commission, so it sounds like it's talking about, I'm sorry, the next sentence talks about that. That's what I meant to say.
That's right. So I think it'll be helpful to clarify. That's helpful.
So just to be clear, the current practice is if the executive director has made a determination that there's no probable cause, that's not reviewable by the commission?
Anything is reviewable by the commission. Generally speaking.
This would be closing off an avenue for the commission to review.
You will get so you have the ability to request or inquire on matters that come before you in the dismissal and closure summaries. We don't envision this to be a closure or to prevent you from being able to continue to do that. It's just clarifying. It was this ambiguity of what do we do with no probable cause finding, right? How do we handle that? Do we post that to our website? No, we can't do that because there's been no finding. So we kind of just wanted to clarify that within the enforcement regulations. But you will have the ability to, as you currently do.
I guess my related question to that is currently complainants don't have a way to appeal to the commission from an adverse finding, right?
That's right.
So we're not removing something that they already had, a pathway they already had.
No, we don't believe we're doing that. We're not doing that. And that's not the intent either.
Yeah. Thank you.
Of course. Okay, slide 20. This is sort of in line with that delegation of preparation of the ED's PC determination. I think I touched on this earlier. It will confer that discretion. It will confer that authority and give the ED the discretion to delegate that to the Director of Enforcement.
Is that
if there's a need to prepare one. And so, like I said earlier, especially if there's any questions about how this is sort of provided before you, we can clarify. I think the intent is to allow the ED to use the PC report as, if it's sufficient by itself and there are no additional, because sometimes respondents don't show up or request a PC conference. So there's oftentimes no additional facts. They sometimes don't even respond to the PC report, right? So all that's before the ED is what has been presented. And we just find it inefficient that the ED would have to go do a whole preparation and drafting of a PC determination. But in the event that one needs to be done, we also are, think it's okay and recommend that the ED can delegate the writing of that to the enforcement director.
Thank you.
Okay. 21. Default orders. This one, again, just deletes that recommendation language, solidifying if you adopt our recommendation that the ED can make a finding. So at a PC conference, if a respondent does not show up, then the ED can make that finding. Let's just clarify that. Okay. 22. Current section 76, commission ratification of ED's PC report. We are recommending a complete deletion of this provision. I've touched on that a little bit. Our current practice, the current provision, I should say, has this process where after there's been a finding, it would go to you. If you have any questions about it, you can pull it, and then there could be a whole hearing on just the PC, the PC process. And we found it has happened in the past that there could be a litigation on the merits, and also all of that material will still come before the commission, right? If there's been a finding, we think it's just more efficient for our process. We have seen an increase in our PC process cases, big impactful cases that are moving through. In the past, this hadn't really been happening. The commission, before the Taylor hearing, didn't have a hearing more than 10 years prior, and now we're at our second hearing, and we have a PC determination that was just released a couple of weeks ago, so there will likely be another one before the end of this year. And we just want to avoid a bottleneck in the process. You will have the ability to review the entire record. The respondent will have the ability to present their matter before you. So anyway, that's what this one is about, in case you had any questions.
Just one other question about the executive director taking the part. Will those probable cause determinations continue to be made public after the fact, as they would when they go through the committee?
Right. So any finding of probable cause will be public. That's correct. That's the requirement and the practice. Yes. It will be posted to our website. Okay. 23. Proposed section 7C7, effect of commission advice or opinion. This one is to clarify and just bring the regulations in alignment with the commission's current practice regarding advice. So the commission only gives written advice and does not distinguish between formal or informal advice. The proposed amendment will reflect the actual practice and also will eliminate the requirement. And then it also clarifies the commission's the opinion of the commission, right? So. And the effect of the opinion of the commission. It's really just clarifying that there was a conflation of advice and opinion, and we wanted to make sure that it was clear that there are two different things, and the pathways actually for the effect, right, of those two items are sort of different.
So in are the references in Roman numeral 1 and 3 supposed to be to 699-12?
I'm sorry, what was your question?
Just confirming the numbering of the regulation that it's referencing. Is that?
Oh.
I'm seeing it as 699 online. Just want to confirm if we have a typo, because it's displayed both ways here.
No, the Roman numerals under 7 are just 7, 1, 2, 3. So go ahead, sorry. I'm not
just
really
in the
following.
text of those sentences, it refers to regulation 669-12. Should that be 699? I just want to confirm the numbering.
Oh, I'm sorry.
Yeah.
I see what you're saying. Yes. Oh, right, Pat, sorry. Do you want to?
I want to make sure I
I can
understand
check
your
that.
question.
Yeah.
Are you pointing to a potential typo, or are you asking
Typo.
what a potential typo?
Yeah,
Okay.
yeah.
And
I think
where
so,
is-
yeah.
and where is it again?
I think it's, I could be wrong, but
I think it's two. I think the regulation is different. I'm sorry, I don't
Okay.
think. The regulation is different, and the charter section is different. So it's regulation 669-12A3, but the charter provision is 3.69912. So it's not a typo, I don't believe. But Kathy can help me look
is
that
that?
up.
Sorry, how about instead of doing this online,
Okay.
we can
Yeah.
work with them to make sure that
Yep.
this is accurate.
Okay.
Okay,
That-
but
that's
it's.
fine.
I don't want to
Yeah.
have to guess.
Yeah.
Thank you. Appreciate that too. We'll make sure
We're
that
not
it's
taking
correct.
action today, so this.
But
yeah.
as written, we believe it's correct.
Okay.
But good question.
Sorry, Ms. Matthews, can I just go back a little? I'm trying to wrap my head around the edits to C3 as well as the proposed deletion of formerly 6 and 7. So as I understand it, in the past, the process was the executive director would make a recommendation of PC and the commission would ratify it or reject it. Is that right?
So the commission, it'll go to the commission, and the commission had 5 days to pull it, sort of how the consent calendar, if you can think about how that works, right? If you have any questions, you can pull it. But if that happens, then it's not ratified, there's a delaying process, and then would have to have potentially a hearing on the question, because it had to be, the parties would have to be able to answer or, present whatever questions that you might have, right, on that. So there will be no ratification until there's a vote of 3 members of the commission to ratify that PC. If you do nothing, it is ratified, and it will just move through the process.
So the proposed changes are to enable the executive director to make a finding, to unilaterally make a finding
Right,
of
if-
PC or no PC.
Exactly.
So removing the commission's role in that.
Until it comes before you for a hearing. And it would still be everything that you would have seen when you pulled it, and the respondent and all parties would still be able to present their matter, right? It just sort of removes that additional review process.
And I think you had said, okay.
And I should note that we've had a few PC reports go before the commission in the last, a couple, right, that have been posted. The Chim and the Walker matter before you, and I don't believe that there was any request to, right, that's what I meant, a couple, not few. Few is more than 2. All right.
I don't want to interrupt your train of thought, and I apologize, but I want to just call a 10-minute recess if that's
Sure.
okay. So we can
No,
resume
yeah,
this
that's
up- yeah,
helpful.
we can go for a while.
And maybe
Okay.
even prior to the Macros one. We have a couple on the website. Anyway,
Okay.
we'll take the recess.
Thank you.
SF Gov TV, San Francisco Government Television.
Thank you.
Acting Chair Salahi, we're ready to resume.
All right. Thank you. Good afternoon, everyone. Thank you for your patience. We were in the middle of item 6 regarding the proposed amendments to the Ethics Commission's enforcement regulations. Just for the record, given that there are 2 commissioners absent today and we will not be voting on the proposed regulations, we have decided to streamline the review of the proposed amendments. And so Director Matthews has additional highlights to point out, and we may have reactions from commission members today, but we'll hear from the public after that, but we'll take this up for action next time.
Thank you, Acting Chair Salahi, Commissioners. So most of the other recommendations up until slide 51, which would be proposed section 10, section 10, which we have discussed extensively. Most of those recommendations I think we can just skip or glance over unless you have any questions. They're areas that we've already addressed in the enforcement guidebook, and these recommendations are really just to, adopt those recommendations to make them clear, our hearing process clearer. So I'm happy to skip to give me a second. I'm happy to skip to my slide, you don't have it in front of you, but section 10, which would be slide 51 through 57, the SOTIF matters, or issue section 10 of the current regulation.
Okay.
All right, so on this specific, I'm sorry, Kathy,
I'm not sure if the slide in front of us is reflecting. I think you're referring now to the proposed
I'm
section
sorry.
11.
Section, yes, so slide, let's go to this one. No, next slide. This one, I'm sorry, slide 52, not 51. Okay, so as you know, for this one, we're recommending that the Commission delete certain areas of Section 10B of the enforcement regulations and amend Section 10A to more accurately reflect what we believe the legal limitations of the Commission's authority under the Charter and Administrative Code are. While the Commission plays an important role in promoting transparency and enforcing ethical standards, it is essential to recognize and clarify the legal limits placed on its enforcement powers regarding the Sunshine Ordinance. I'm just going to read what I have prepared for the record. I think it's important, if you permit me. I know you've heard this many times already, but so the Sunshine Ordinance codified in Chapter 67 of the Administrative Code, created the Sunshine Task Force as the primary administrative body for hearing and determining complaints of alleged violations of the Sunshine Ordinance. Excuse me. While the Commission plays an important role, like I mentioned, in promoting transparency, it's essential to recognize, again, this the legal limits that's placed by the Charter and the Ordinance. The Commission does not have authority under the Charter or Sunshine Ordinance to impose fines for violations of the Sunshine Ordinance, willful or non-willful. Under the Charter, the Commission may only impose penalties for violations of the Charter or of a city ordinance relating to campaign finance, lobbying, conflicts of interest, or governmental ethics. And this is within the provisions of Section C 3.669(1)(3), subsection D. The Sunshine Ordinance does provide the Commission enforcement authority over willful violations of the Sunshine Ordinance. And we've reviewed, I'm going to skip over what 66734 says about willful violation. This only applies to elected officials, department heads, and managerial employees. This provision clearly excludes conduct by lower-level city employees or other parties, as well as unintentional violations from the enforcement purview of the Ethics Commission, and the only remedies available are for the Commission to recommend that the elected official or department head be removed from office for official misconduct, and or to direct the official to comply with the Sunshine Ordinance without any practical means of enforcing such directive. So in order to address these limitations, and many more I can go on, but we can also just discuss, we're recommending a deletion. I'm happy to answer any questions. I think you're fully informed and you've heard a lot on this, so I'm not going to go on for now.
Thank you. Yeah, I don't personally have questions about this topic right now, but it's something for us to think about given the issues that have been coming up.
But that's for now, I think, all that's like really substantive, except for maybe, okay, there's one more actually that I just want to touch on. Slide 59, I believe this should be slide 59. This is proposed sections 13C, the use of donor or legal defense funds. Here, we're addressing the use of such funds and clarifying that such funds will not be accepted as payment for any assessed administrative penalties. Excuse me.
And is the effect of this to require personal accountability by folks who have penalties assessed against them?
Well, sorry, I didn't hear your question, but I just, you can, if you don't mind, I would just add to what I said. This also deletes the provision regarding payments, installmental payments. That's not a practice of the commission, and so we're just taking that out to align with our practice. Installment payments is handled by a different city department, and we have a way of advising respondents to seek such a remedy, and they're able to. Oftentimes, they go to the BDR. What's that stand for again? Bureau of Delinquent Revenue, right? So they can go there and request that. It's just not through us, and so there's no reason to have that within our enforcement regulations. But they still can do that.
That makes sense. But the change about not accepting the use of donor funds, or legal, the effect is that the effect of that is that someone has to personally pay for.
I'm sorry, I can't hear you.
Oh, I'm sorry. That's my fault. Okay. Is the effect of the statement that the ED will not accept the use of donor funds or legal defense funds to pay any assessed administrative penalties basically just requires whoever is assessed a penalty to pay it personally out of their funds? Or
they pay personally, however, but not through donor funds or legal defense funds. So essentially pay personally, yes. Sorry, there's one more that I want to highlight. I'll just talk about it. We think this is important. The ability for respondents to offer proof for their inability to pay fines if they're experiencing financial hardship. Our current enforcement regs are a bit too strict on what that proof requires, and there's ways that other departments handle such, and so we just wanted to address that and make it a little easier. There's ways that we can ascertain that without requiring that they provide those specific proof. So I just wanted to highlight that. If you want to turn to that now, we could, but I don't think it's necessary. Okay.
No.
Just two tiny, very minor things because I'm pedantic. I just suggest that the legal defense fund not be capitalized because it doesn't seem to be a defined term. And then 12B2, there's a good cause provision there, but I'm not sure why that's necessary because it doesn't. Good cause is already defined, and I don't see good cause anywhere else used in proposed section 2, the late filing fees portion, so it sort of seems extraneous. But
we'll take a look. Thank you.
Thank you. We have received, do you have any questions right at the moment? No. Okay, I have like one small reaction, but I know we're going to take up most of the discussion later in case helpful might be useful to do that. I was kind of struck by the new good cause definition at the top that applies to extensions, not in terms of what you decided or recommend be considered good cause, but the documentation requirements strike me as somewhat onerous. So I don't know if you want to consider not making that a requirement, but providing yourself the discretion to require it if this becomes like a repeat problem with somebody, or there's reason to doubt it. And then we got a number of public comments raising some concerns related to the provision, several of the provisions, including about reopening cases and confidentiality and some other issues. And I was wondering if you have reactions to those now that you'd like us to consider.
The public comment that regarding reopening cases, I'm more okay.
And it's okay.
I think the focus was, I think it was mentioned, but I think more the focus of that one was about the, right, like you said, confidentiality provision regarding the complaint itself. Yes, I do have a response to that. First, this is contained within the charter, right? This provision, this is not a made-up thing. We're prohibited from disclosing, including investigative records, including the complaint. And respondents are, I have several points in response to this comment. Respondents are already informed of the nature and the scope of the investigation. While the actual complaint may not be shared, it is the regular practice of the Enforcement Division to fully inform respondents of the nature and scope of investigation and potential violations that are being examined as necessary to further investigation. And this is usually conveyed through a regular investigative process where the investigator will reach out either via email or phone call. Even when we issue subpoenas, we outline the code sections, the violations that are at issue. It's important that we inform respondents of that, the nature of our investigation, because we want to get the facts right. So that's something that's already being done. The suggestion that respondents are left in the dark is just not true. They've been able to engage meaningfully with our investigative process through our current practice. And we continue to see great outcomes in our investigative work. Also, confidentiality is it's a really important, critical, it's critical for protecting whistleblowers and complainants. The Commission has a core responsibility to protect the confidentiality of complainants, many of whom are whistleblowers and act in the public's interest. So ensuring their anonymity and safety fosters trust in our process and encourages individuals to report suspected violations without fear of retaliation or exposure. And we strongly believe that fearing that the Commission will release the complaint itself to respondents might hinder complainants from coming to us to provide us with useful information. Also, like I mentioned earlier, the charter does mandate that records of any investigation shall be considered confidential information to the extent permitted by law. Additionally, the comment mentioned what other jurisdictions do. That might be true, but our sister jurisdictions here in LA and San Diego do not release copies of the complaint. They consider it confidential investigative record as well, and they find it's the same part of the same rationale here regarding protecting the the integrity of the investigation. In addition to the charter mandate that we have, also many of the significant investigations that we do are not complaint initiated. They just aren't. So there is no complaint to be disclosed, to be released. We initiate a lot of our complaints through audit findings, data analysis, or just staff-initiated reviews that happen. In such cases, like I said, there's no external complaint. We can reach out to folks. We inform them fully of the nature of investigation. We're not hiding anything from them. It doesn't do us any good to hide any information from them. And the process remains robust, fair, and without the need to produce a complaint. Also, another point that I think is important to raise is that disclosure risks undermining interagency collaboration that we have. A substantial number of investigations that we get are referrals from other city departments and law enforcement bodies, and these entities often share information with us with the expectation of confidentiality, and we do not want to undermine that process. And so for these reasons, I'm happy to answer any specific other questions that you have, but for all of these reasons, and we also don't believe there's a legal requirement to release complaints, we believe that this should just not be the recommendation by this law firm should not be adopted.
Thank you.
Welcome.
Do any of the commissioners have any further comment? Okay, well, we won't be taking action on this today, but we do want to hear from the public if there's any public comment on item number 6. If there's anybody in the room who would like to speak, please step forward.
Well, good afternoon, commissioners. My name is Dr. Derek Kerr, a whistleblower. Since 1995, the Ethics Commission has been assessing whistleblower retaliation claims. But over those 30 years, not one retaliation claim was sustained among hundreds submitted. Compare this record with the gold standard, Navex Global's Whistleblowing Benchmark Report. It's available every year. It covers 4,000 whistleblower programs that handle 2 million complaints worldwide. Retaliation claims were sustained 18% of the time in 2024. In prior years, those rates ranged from 16% to 23%. But here in San Francisco, we get zero year after year after year. Now the ethics staff want to hide this miserable record by scrapping the standalone summary of retaliation investigations. In 2020, the Budget and Legislative Analyst issued a performance audit of the Ethics Commission. Of 34 retaliation claims over 3 years, none were sustained. And the reasons for dismissing them were hidden. The audit urged, quote, enhanced transparency, unquote. Whistleblowers do face retaliation. Ethics investigations conceal this reality. A standalone summary prevents your dead-end investigations from being completely buried. Thank you very much.
Thank you. I think we'll alternate between people in the room and callers in the queue if we have any callers in the queue.
Yes, we have 3 callers in the queue. Caller, can you hear me?
Yes, this is Jim Sutton. Can you hear me?
Yes, your 3 minutes starts now.
Thank you. We certainly appreciate staff's effort to update the enforcement regulations, but there are kind of several policy issues that we believe deserve maybe to be separated out and discussed by the commissioners separate from the more technical updates. The first is not being able to use donor funds or legal defense funds for fines. Although that has surface appeal and it sounds good, it is really not workable and not fair. First of all, the commission does not just find candidate committees, it also may find ballot measure committees or PACs. Ballot measure committees might not have a sponsor or any kind of individual who is directing the ballot measures activities other than perhaps the named treasurer or principal officer. If this regulation is adopted, our firm would certainly not ever act as a treasurer for a political committee for fear that staff would try to come after us for what were violations of committee personnel, not of our firm. And even for candidates, it's really too broad to prohibit candidates from ever using their committees for fines. Most of the violations that come before the commission are more technical. Missing a disclaimer on a mailer, not knowing that a person was on the board of a nonprofit going after a city contract. And there really is no public harm in letting those fines be paid by a legal defense fund or by the committee funds. The second proposal that we believe has problems is the definition of good cause. The proposal would exempt a first-time filer as a good cause reason, although it is very common for individuals or businesses who qualify as major donors for the first time to have no idea they might have that filing obligation, or also major donors or committees that usually file with the state, the Secretary of State, might not realize that their activities have changed and they have to file with San Francisco. We think those are appropriate reasons for good cause. Thank you.
Thank you for your comments.
Hello again, Dean Schmidt, Sunshine Ordinance Task Force. I want to speak just specifically to the proposed edits to Section 11. We had discussed some of these issues earlier with regards to line 4, the Lataki matter. I will try to not be repetitive on what I said there, and in order to do that, I'm going to just address the documents that are in the file. First, the recommendation that's made to you in terms of why to adopt the changes to number 11, which is about procedures for sunshine. The first remark I have to make is that there's certain language in here that seems, I think it indicates a predisposal or an attitude towards sunshine claims. Such phrases as merely negligent or unintentional, minor or unintentional open government infractions, technical or non-willful violations. It seems there is an emphasis on this idea that what we see around the city in terms of sunshine compliance is minor, technical, negligence, unintentional. And that's not actually, it's not based on, there's no citation here to anything. These seem to be matters of someone's judgment, whoever may have written those comments. And it's also not what we see at the Sunshine Task Force. We see a lot of cases that are not merely technical, merely negligent, merely minor or unintentional. And I think to base any kind of changes here on that type of language is to ignore the reality. The other item that I want to mention is the two aspects of One, the charter somehow affecting the Sunshine Ordinance and limiting the extent to which this body needs to enforce the Sunshine Ordinance. I do not think that the charter says anything about.
Thank you for your comments.
Is there any phone callers in the queue?
Checking the queue to see if there's any callers. We have 2 callers in the queue. Caller, can you hear us? Caller, can you hear us?
Yes, can you hear me?
Yes, your 3 minutes starts now.
Thank you very much. This is David Lazarus calling. I'd like to begin by thanking the staff also for their work on the proposed enforcement regulation amendments. I'd like to second the suggestion from Mr. Sutton in his public comment. There are some significant policy and substantive changes that are proposed here that go beyond the way of narrowing and streamlining and enhancing commission enforcement procedures. And I do think it would be appropriate for the commissioners to have a dedicated process to look at those maybe 3 to 5 issues where the proposals would have a very significant impact on the enforcement process, which of course is a very sensitive process that threatens reputational harm and the ability to execute mission objectives in sensitive First Amendment fields of things like pursuing ballot measure changes, advocating for and against candidates, and seeking redress from elected officials. I would also like to second Mr. Sutton's attention to the issue of individual liability. This would be a significant departure from state law, what's proposed here. It's also a significant departure from widespread practices in terms of ethics and campaign finance enforcement, where typically campaign committees, ballot measure committees, other entities like nonprofits can use existing treasury funds, which are comprised of donor funds, to pay administrative penalties. The discrepancy between the proposal here and widespread practice, I think, could chill political activity, protected First Amendment activity, in ways that Mr. Sutton suggested and others, discouraging individuals to engage in political activity in the jurisdiction, discouraging people from serving as treasurers or responsible officers. And the proposal as currently laid out would in fact discriminate between entities like nonprofits, which have donor bases, and other entities that might be funded with general revenues. So just to follow Mr. Sutton's point, it would be unworkable in certain circumstances to draw which individual in a political committee, a PAC, a major donor, is responsible for the error. Typically, entities are identified as respondents. I'll point out a couple of other points really quickly. We will follow up with more comprehensive comment. In terms of ratification of the probable cause process, we believe that the existing process should be maintained and that commissioners for this very important decision should retain authority over making probable cause determinations. We also think some of these changes should be made prospective only. We'll follow up with additional comment. Thank you for your time. Appreciate it.
Thank you for your comments.
Hello, this is Matt Yankee again from the Sunshine Ordinance Task Force. You all should have received a written communication I talked about earlier that we prepared after significant discussions in the task force, but I wanted to just touch on a few what I think are some of the most important points that we really want to see included in these revisions that don't seem to be there. The first is a working definition of what a willful failure is. I've been told by Ethics Commission staff verbally that they consider it, quote, nearly impossible to prove a willful failure. Some definitions of that term might lead to such conclusion, some may not. And it's not clear that the task force, all of you, city officials, and ethics staff all are using the same definition of what a willful failure violation is. So we really think that that needs to be identified and put in writing so we all know what target it is that needs or doesn't need to be met. Secondly, we feel very strongly that any things that we send over for a willful failure violation need to be put in front of this commission and heard publicly. Again, these represent less than 2%, if not even less than that, of the cases that we hear. And we believe those are some of the most egregious matters that we've seen. These are not minor. These are not inadvertent. These are cases that we've spent hours in public meetings, dealt with multiple officials, and typically, actually in anything that's willful, we've always engaged the department head directly on those matters. Yet they haven't gone to a public hearing here. We find that troublesome. That's something that needs to have full transparency. And the last point is, I think we've all kind of come to the conclusion that there are some shortcomings when it comes to enforcement mechanisms. And so what we're asking is we would love to work with you folks, the Ethics Commission, and perhaps we can figure out a better way, changes in the law, so that more appropriate enforcement mechanisms exist. While court remains an option, obviously, for folks to use, I think what sets San Francisco apart in its transparency laws is the fact that folks don't necessarily have to go to court. There's a way you don't have to get a lawyer and pay the filing fees and all of that. And we really want to work collaboratively with all of you to find solutions for enforcement that makes these laws worthwhile for all of our time. So thank you.
Thank you for your comments.
Mr. Clerk, do we have any more callers in the queue?
Vice Chair Salahi, we have one more caller. Caller, can you hear me?
Yes, James Carson from CPAA. Can you guys hear me?
Thank you. Go ahead. 3 minutes starts now.
Thank you. I submitted a letter on behalf of CPAA last night. I just wanted to highlight the due process concerns with reopening. We outlined those in our letter, but we think there are significant issues, certainly in the context of settlement or stipulated termination, and the authority to reopen a case could upset those negotiations. There's also, while there are some limitations written in the code, there's no clear process, certainly no identification of who has authority to reopen the case. Is that staff and investigators? Is it the enforcement director? There's no process laid out to do that. There's also no notice that's given to respondents in there. So I think there's still a ways to go in terms of addressing the due process concerns when we're reopening or potentially reopening a case. We also, I want to echo my colleagues' comments about the idea that these are only prospective changes. When you have cases that have been settled for years, suddenly subject to being reopened, should these amendments pass, you're really opening up a Pandora's box there. So we think any changes to the enforcement regulations should be prospective. Thank you for your time.
Thank you for your comments. Vice Chair Talahi, we have one more caller. Caller, can you hear me? Caller, can you hear me?
Can you hear me now?
Yes, your 3 minutes starts now.
Great, thank you. David Pilpel again. Several quick comments. First, as preliminary matters, the June 30th notice only included the chart and the red line text, not the staff report. The Sunshine Ordinance provisions refer to a summary above, which was not included. Also, the email from Chair Yankee and I believe the other communications that were just referred to do not appear to be posted on the Commission's website, contrary to Administrative Code Section 67.9, California Government Code Section 54957.5, and the notice at the bottom of today's agenda on page 4. You may want to inquire whether this item can be further considered today and find ways to post properly communications received. Finally, the slide presentation is not posted on your website and should be posted before the meeting. On the substance, the staff report fails to mention the second round of interested persons meetings. It was discussed in the presentation, but it's not in the staff report. I support and emphasize the communication from Chair Yankee on Sunshine Ordinance matters. The task force wants to clarify and give effect to all the existing ordinance language, however difficult that may be. We also see the need for more clarity in the law itself and want to work with you to that end. I think the task force wants to see clear language and engagement, but rejects what is here today. Very briefly, in non-sunshine areas, the language that I saw at 7C3 hangs at the end. It sort of trails off. Overall, it is not clear to me whether there's more, less, or the same public disclosure about complaints and their status. While the Commission gets regular reports on complaint status, complainants and respondents may get no interim notices of status for months at a time. Periodic notices to parties may be helpful, and including that in the regulations may be useful. The public also sees very little information on complaints, which doesn't promote confidence or transparency. I urge you to make as much status information on complaints public as possible, consistent with the confidentiality provisions of the Charter. For example, adding at the end of each operative section of the regulations, if there's a change in status, that it will be either posted or not posted on the Commission's website and included in the next Executive Director's report to the Commission, so there's no lag in reporting. And finally, the process recently approved in San Mateo County regarding the removal of its sheriff may have some interesting procedural timelines and safeguards that staff may want to consider in this context. I hope my comments are helpful and were heard. Thanks for your time.
Thank you for your comments. Vice Chair Salahi, there are no more callers in the queue.
Thank you. And thank you to everyone who submitted public comment in writing. It's very helpful. We have seen it all, and we're continuing to review it before the next meeting. Public comment on item 6 is now closed. Do we need to move to table, or can we just?
No, you can just take no action.
All right. I now call agenda item 7, discussion and possible action on items for future meetings. Does any commissioner wish to speak to this item? Okay. Hearing no requests, we'll take public comment on item number 7. I don't see anyone in the room. Is there anyone in the telephone queue?
We do have one person in the queue.
Okay.
Caller, can you hear me?
Yes, can you hear me okay?
Yes, your 3 minutes starts now.
Great. David Pilpel, just to reinforce that last point about comments that you just referred to that you received in connection with the prior item, to the extent that that's continued to the next meeting, if you could really just ensure that those comments are publicly visible on the website, that would be helpful so that we can all see it and not just the staff and the commissioners. Thanks very much.
Thank you for your comments.
Thank you. Public item is now closed. Just to confirm with the commission staff, will that material all be posted on the website, the incoming public comment? Yeah. Okay, thank you. I now call agenda item 8, additional opportunity for general public comment. Any in-person member of the public who wishes to provide comment, please proceed to the podium. Seeing nobody, is there anybody in the queue?
Checking the queue for callers. And there are no callers.
Okay. Thank you. Hearing no further callers, this additional opportunity for public comment under item 8 is now closed. I call agenda item 9, adjournment. Thank you. This concludes the July 11th, 2025 meeting of the San Francisco Ethics Commission.